So hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asiedu Entry. Today we are looking at basically two things. And in fact, we have a very prominent person on our platform. One I've longed for so long to have on this show, and he's here. I'm having the Honorable, the Member of Parliament for the good people of Ofuasia Yorubi, former Minister for Works and Housing and Information, Honorable Kojo Oppong Nkrumah. Welcome.
Thanks, Aaron. How are you?
I'm doing well, sir. I just find out yesterday, even yesterday, a couple of dates, you are Vincent. Why don't you use it?
No, I do. It's in my passport. It's on my birth certificate.
Oh, okay. But you signed all your official releases when you were minister.
Yeah.
As Kojo Oppong Nkrumah, ignoring the Vincent.
That one, I keep it in abeyance.
But how is opposition?
It's okay. There's a lot of work in opposition to do. The opposition benches are part of Parliament. So when you talk of the legislature, the opposition benches constitute a very important part of it. And if you are in the governance space to serve, it's not every day that you'll be in power. There'll be times when you'll be on the opposition benches. And when you get there, you also have to then do your best to play that particular role as well. So
the normal saying that the government of the day or the majority have their say, you have your say, minority, you have your say, and they have their way. Is it practically so? Or
most times it is, because I think in Ghana's democratic history so far, even from the First Republic, save the Third Republic, it has always been the case that the party that has won the executive branch has got an overwhelming majority in the legislature as well. Because usually our elections come with winds of change. So what ends up happening is that the opposition benches are usually limited in number, and therefore all they can do is to have their say. And the majority benches, or the government benches, which are aligned with the executive branch, they will end up having their way. In the last parliament, however, it was slightly different because it was a near-hung parliament. So the opposition got their way many times, also because there was a speaker in the house who was from the opposition party. So mostly been the case, not always.
That should bring a lot of MPP MPs into question and why that happened. But that is just by the way. Maybe somebody thought of expressing his view the other way around. But opposition have its say, majority have its way. Probably will feature prominently in our discussion today. Because today we are looking at basically maybe three things. The private members bill you are seeking to introduce. Then we will look at the Cybersecurity Amendment Bill and the Misinformation and Disinformation Bill. But first, I've heard a couple of times, Joy News reported that you are seeking to bring in private members bill. What is it about? Briefly, then we move to that.
If you look at Ghana's constitution, it suggests that the government or the controller of the public purse is the one who is given the predominant space to bring legislation. In fact, if you look at Article 108A2, it suggests that Parliament shall not work on any bill. No bill shall be considered if, in the opinion of the person presiding, it imposes a charge on the public purse.
So the one who gives the definition of whether it places a charge on the consolidated fund or any public fund is that of the one presiding.
Yes. And if you look at the jurisprudence of decisions by the speakers of Parliament, until Michael Quay took the chair, in fact, most speakers...
He's Aaron, so I take credit to that.
Most speakers, until Aaron Michael Quay, were of the view that anything that amounts to even one pesewa charge on the public purse should not be allowed by a private member of Parliament. So it's only the government that can bring such a bill. And it's understandable because they are the ones who are raising the money and allocating its expenditure. And so it should not be allowed for a private member to come and put a charge on it. Speaker Michael Quay was a bit more liberal and then said some tests have to be applied. And he then started the allowance of private members' bills. So private members' bills essentially allow a member of Parliament in his private capacity to propose a bill if it will not impose a charge on the public fund. Now, the bill I am seeking to have Parliament pass into law, and hopefully the President has sent to, is a law that seeks to close some loopholes in the current Public Financial Management Act.
The PFM Act.
The PFM Act.
Okay.
In the construct of the current PFM Act, when a minister or head of an agency or an assembly requires funding for any program, they go to the finance ministry and the finance ministry allocates a budget. They are not required to prove some things, which things I think are seminal. 2, 1, they should prove that whatever they are going to spend money on is in consonance with the National Development Plan that has been approved.
NDPC.
Yes.
Their plan.
Yes. Okay. That is not in the current PFM Act.
Okay.
Secondly, I think that they should even prove that the last time they were given money, they have reported on what they used it for.
You think, or that is the position of the law?
That is not the position of the law today. That is why I'm seeking by a private member's bill to introduce those amendments. So those amendments that hopefully I will be tabling on the floor essentially say that if you don't have a plan that is in sync with the National Development Plan, the finance minister should be estopped from giving you funding. If you have not reported on your annual progress report for the last time you were giving funding, the finance minister should not give you funding. Same applies to the district assembly's common fund administrator, and same applies to internally generated funds. That's the embodiment of the private members bill that I am working with Parliament on currently.
If I may ask, your formal reason on the fact that it must be in consonance with the NDPC plan, that is grounded in law.
Not exactly. So if you read the current, if you read the current section 21 of the PFM, it just says approved plans.
Okay.
Whose plans are we talking about? Approved plans of the ministry, or approved plans of the president, or approved plans by the NDPC? So if you go to Article 36.5, Article 36.5 says that when you have won power as a president, you have to within a year or two.
For the purposes of this, for the purposes of the foregoing clauses of this article, within 2 years.
Within 2 years.
After assuming office.
Yes, the president have to submit your
coordinated program of economic and social development policies, including agricultural and industrial programs at all levels in all regions of Ghana.
Essentially what it is that your manifesto, you have to give it to the NDPC for them to convert it into a 4-year governance document. That is a medium-term development plan of Ghana. That is the one that finance is now going to be using to program what we call the MTEF, the medium-term expenditure framework, and then the medium-term debt strategy, and then the fiscal strategy document of how to raise money for you to achieve that. Now, where you have ministers, heads of departments and agencies getting money outside that plan is the lacuna in the law that I'm seeking to close with this amendment. So as a first step, you have to prove that this plan that you want money from is in sync with the plan approved by the National Development Planning Commission. By the way, that plan is the president's plan.
Okay.
So once the president has won another Article 36.5, he has gotten his plan done for him. Your spending must be in sync with that one.
So I have 2 questions, one legal, one moral. Let me start with the legal one. Chapter 6 of the Constitution, which houses Article 34 to somewhere 41, is a directive principle of state policy.
Yes.
It is not justiciable. I even have a problem when people say justiciable. It's not enforceable. And when Dateba brought a finality that it is now presumptively justiciable. So we should read it together with some other provisions. So you don't think that the president is not really compelled under this to put out the programs. That is why successive government has not been able to do that. You don't think so?
The law-making process is dynamic. So where we find that there are elements of confusion or disagreement, we tidy it up with lawmaking.
Okay.
So even if I am to agree with Professor Justice Dateba on his, what will be the latest determination on these directive principles of state policy, it is actually the more reason for which elements within it, which we believe must be subjected to enforceability, must be tightened up with legislation like what we are doing now. So, for example, 36.5, which ordinarily somebody would have said is not enforceable. We are saying that by section 21, hopefully as amended, like the way I'm seeking to do it.
The PFM Act.
Yes, it will now impose an obligation on the executive branch through the finance minister to ensure that, first of all, 36.5 is complied with, and the new 21 is also complied with before money is made available to anybody to go on a frolic of his own in a republic.
I'm sure legal luminaries and all the lawyers will be arguing whether, as we all know, that the Constitution is supreme. The laws provided here are supreme. When it is not enforceable and others, whether this would be, well, I subscribe to the argument you've made. But the moral argument, Kojo Oppong Nkrumah assumed the office of Deputy Minister of Information somewhere March or April 2017. 2 years later or 3 years later, you became Minister of Information.
That is so.
Thankfully, and God being so good, you were part of the economic team moving around all this World Bank. And I was listening to you a number of times when you were in Washington, when you were in Morocco. One time, I think you were in Casablanca also, speaking to Asempa and others. Is it now Kojo Oppong Nkrumah, even serving in cabinet later as Works and Housing Minister, has now gotten to know that we need to tidy this up? What were you doing for the past 8 years you served as minister of this country?
And I think that's a very fair question. Mm-hmm. The first answer to that is to even assume that all that you have said is accurate and that it was something that could have been done earlier. This democracy we are running, this lawmaking process, as I mentioned, first is dynamic, and it's an exercise in constant improvement.
Well, Minister, you don't...
If I may land with
okay,
answer.
Sure.
When you have done something for a while and you have observed that it can be done better this way,
okay,
you have an obligation not to say that perhaps during our time it wasn't done and therefore we are going to bed. Then the society will never improve because nobody then will have the moral authority to advance a course in improvement. So even agreeing with your premise, having observed all of those things, then you now take a step that we ought to move this a notch higher and tighter. I'll give you an example. Nana Akufo-Addo had served in President Kufuor's cabinet from 2001 to 2008.
7.
The imposition on free, compulsory, universal basic education was in the Constitution. It didn't change. But in 2007, 2008, when he now was contesting as a presidential candidate, he sought to move it forward by proposing a new program, the Free SHS program. Somebody would have argued about why he served in government for that period. Why is he now saying it's an exercise in constant improvement? And I'll give you more examples, even with the current president, John Dramani Mahama.
Okay.
He had opportunity to serve.
Yes.
From deputy minister to vice president to president. Yet, in 2020, 2024, when he was contesting, he was still pushing new ideas that he will introduce, for example, something he calls an Nkukon Kitinkiti program or some other programs, coding program, etc. Why? Because it's an exercise in constant improvement. So we cannot use that argument that if you served in a previous administration and something wasn't done then you are stopped from ever advancing new ideas. No. And actually, even if you had done something and you had failed at it, you have a better understanding. That's what they call failing forward. You have a better understanding of how it did not work. And you are well placed to offer help in getting it done better.
I agree with you because I see a lot of commentaries on Facebook that because you were in government, this happened and you are now out of government, you shouldn't raise it. Personally, I have issues with the Office of Special Prosecutor, the current managers of it. I raised it and people are asking, but you join MPP here and there, and I find it quite ridiculous that people would even advance such an argument. Because if it is not right today, if it was right yesterday and it's wrong today, you must raise your voice about it.
In addition to that, the fact that you even subscribe to the MPP does not mean that you were the Attorney General in that time.
Thank you.
Or that you were the majority leader of that time. So if today the MPP is not in power, and let's say you are on the opposition benches, you've been given a different portfolio, and there's an obvious gap that needs to be fixed where you are now playing, you are well damn right to propose how it should be done.
Right. So I think as we progress, when it is being laid before Parliament, amongst others, we will have a conversation on it.
Very well.
You've served as Minister of State. You've dealt with information. You've dealt with works and housing. I want to understand. I know when you want to introduce a bill, it goes through all number of stages as provided in Article 106. But prior to that, how is a bill even introduced? How does it go through cabinet? Before I understand the Cybersecurity Amendment Bill, because I've read it overnight, honestly, I'm having a lot of issues with it. I want to understand that before we look at the Cybersecurity Amendment and the Misinformation and Disinformation.
So if you look at Article 106 of the Constitution, there's a requirement on people who are proposing legislation, first, to be able to explain the mischief that exists that needs to be cured.
Okay.
Embodied within that constitutional requirement is the expectation that if you, as a government, want to propose legislation, the government would have come to a certain view on a mischief for which you are proposing there should be amendments or corrections. For example, when we spoke about the Public Financial Management Act, I've shown you the mischief that I think exists under Section 21, which should be improved, which should be corrected. So the first thing is that when the current administration says it wants to amend the Cybersecurity Act, what is the mischief that they have observed? When they say they want to pass a new bill, the Misinformation, Disinformation, Hate Speech and Other Information Bill, they want to pass it in, what is the mischief? And you will find the mischief explained in a public policy statement made by His Excellency the President the first time he met the press. That the government is uncomfortable with some comments that people make on social media, simpliciter. And that the government intends to criminalize such comments. If you follow the words of the president said, for those who are on TikTok and other things who are doing hate speech and other comments, we will come after you. We will use your IP addresses and we'll get the National Signals Bureau to come after you. And I believe that your viewers will attest to the fact that this was a public policy position expressed by the president. Subsequent to that, his Ministry of Communications is now drafted a set of bills which actually seek to criminalize free speech that the government considers as hate speech or as false speech. Now,
I want to get a difference. Are they seeking to criminalize free speech or they are criminalizing hate speech?
I would explain to you why, in addition to my uttering of the words hate speech, I also further mentioned free speech.
Okay.
But let me just land on your first question. So what's the process? So the process is that the ministry would have done its consultations and draft. We'll go to cabinet, and then cabinet will give approval for what you call stakeholder consultations, public engagements. And then subsequent to that, it will be laid before Parliament, for Parliament now to be seized with the proposal of the executive branch and now to act on it. Now, we do understand that they are currently doing what they call the public engagement or the stakeholder engagement.
Okay.
So we are allowed to presume that they've gone to cabinet, they have received cabinet approval, and it is based on that they are coming to stakeholders or the general public for a view, because that is the norm. When we were in power, you go for what we call policy approval. The question is it within the public policy contemplation of this administration that we want to pass this bill? They will give you that permission that go, yes, it is within our contemplation. And then you draft the bill. And when you have drafted the bill, you come back to cabinet for approval on the draft bill. When you are given approval, then you go and do your stakeholder consultation. So from that practice, we are within our force to assume that they have cabinet approval for this. So at this stage, they are consulting on whether or not the public will agree with this proposal from government, and then they will bring it to Parliament properly. That's where we are now. And it is in this consultation process that we are drawing attention to the fact that though the advertised intendment, for example, of the Cybersecurity Act, if you read the memo, which is to deal with things like cyberbullying, cyber stalking, though those ones are commendable, there's a dangerous provision that seeks to criminalize free speech, where they say that if a determination is made that a publication, whether on social media handles or even chat groups, like WhatsApp group, is false, you could go to jail for up to 10 years.
So this is the misinformation bill you're talking about?
This is the misinformation bill. And then for the cybersecurity, no, in fact, for the misinformation bill, media houses could even lose their licenses. And then
when they publish false,
when they publish something that is determined to be false by the misinformation unit or division that they are creating within the cybersecurity authority. You see, that determination is not going to be made
by a court,
by you or by me. is going to be made by a division within the Cybersecurity Authority that you want to set up, the Misinformation and Disinformation Division. And we think that that is dangerous. You don't give that power to a state agency to determine what is true or false. In fact, the remnant laws on publication of false news with intent to cause fear and panic, I think section 280 and 185 or so of the Criminal Offences Act, there's even strong advocacy that you either repeal it or you subject it to more fetters to prevent the state from abusing it, as we're observing is being abused now. So if you now escalate it to a level where now the Cybersecurity Authority is going to have a division that will determine what is false, and that they are now going to accredit what they call fact checkers, who will also be now accredited entities telling the public that this is true, this is not true, as accredited by the state, then you are going to dangerous territory. So what we have said is that, fine, they are consulting. Our view in this consultation is that those provisions that seek to criminalize free speech should be taken out. The provisions on cyber stalking, all of those ones, I think they are good. They protect everybody in the society, including children, etc. But those provisions that seek to say that if somebody says something that is deemed to be false by their division, that person could go to jail, not less than 1 year, not more than 10 years, or a fine. You ought not to criminalize free speech. That is the key argument that we have.
You see, it even infringes on the principle of rule of law, because certainty and predictability of the law, now you leave it to the discretion of a certain division of a state agency. Personally, during the Chief Justice brouhaha, my issue with it is just similar to this. If you say stated misbehavior, and per our criminal jurisprudence, 1911 says define it.
What's the guideline?
So you leave it to a 5-member committee to make a determination on that, okay, this is stated misbehavior. Tomorrow, another government comes in. And when a justice of the Superior Court goes to buy gobe by the roadside and shouts on the gobe seller, it may constitute
to the extent that they can justify it among themselves, and it's not subjected to any standard elsewhere. So yes, it is in this same light that we are saying that if you go that way, you are beginning to roll back the progress that has been made on expanding the frontiers of free speech, which is a seminal pillar of a democracy like the one we are trying to build.
So this is what the Minister for Communications, the Honorable Samuel Nate George, said when he was in opposition as deputy ranking.
Fighting cybercrime is flawed. You already have the infrastructure today that is fighting cybercrime. You have a national cybersecurity advisor at the ministry. There's a national cybersecurity center. There's a joint interministerial working group on fighting on cybercrime that has the Minister for National Security, has the Minister for Communications, has the Minister for Justice and Attorney General, has the Minister for Interior. There are about 7 ministers on it. And the structures exist. If you are setting up an authority, that is just a bureaucracy. The bureaucracy is going to be responsible for policy, regulation, and frameworks. That authority is not going to be responsible for the fight against cybercrime. The fight against cybercrime across the world has never been done by governments. It is always done by private sector agencies. What you will see is that government is going to say that, okay, for the justification of...
Now, he suggested that it shouldn't be the work of government. I find it quite interesting that there's always some judge that comes under that. I know you don't want to personalize it and make it about persons, but is it only the commentary you are making on as a minority, or you are taking a further step to ensure that you contribute to this? Because I've gone through it, I've made notes on it, and I've looked at it throughout the night. And in fact, there are other provisions that are even sensitive than they talk about registration of certain information or so. In fact, they can even withdraw it and charge you.
Some institutions can then be designated as critical national, information infrastructure, etc.
Yes.
But the first thing that we have done is to draw attention to the part that deals with what we consider fundamental, may I say, reversal of some of the rights that the Constitution 1992 gives us. That's the first thing we've done. Number two, I think our Committee on Communication and Information has done a detailed job and will be submitting their views to the ministry. Number three, it is our expectation that by the time the final bill gets to Parliament, these provisions would have been expunged. If not, when Parliament is fully seized with the bill, our side of the House is going to employ all the legally acceptable means to ensure that those provisions do not become law in Ghana.
I was in this house when you were passing the Gold Board Act. I saw you, I saw the Honorable Member for Jabin, I saw a lot of people making commentary, but we still have the Gold Board Act.
So there are different, but you recall that in the Gold Board Act, we did not say that we will ensure that so and so and so provisions do not become a part
of it. But the provisions you were raising were critical.
We drew the attention of the government that this way you are going, we have been there, we think it is inimical to the interest of the state. If you want to go there, God bless you, you will see the consequence down the line. For example, you remember that the PMMC was a company owned by the government of Ghana with shares and with a requirement to publish their accounts in accordance with a particular structure. So if they were making profits, you could see the shareholders' equity growing. If they were making losses, you will see a depletion. When they brought the Gold Board Act, they wanted to now convert it from a company to a statutory corporation, which is not capitalized. They are not required to make profits. They will get disbursements from the finance minister. It becomes a sinking hole. Today, all sort of issues are coming up. Remember, we filed a question to the finance ministry. They say they haven't given them any money. There are questions, therefore, about where they are getting money to trade from.
It's coming from BOG.
There are quarterly publications they are supposed to do, which they haven't done. There are so many things that we warned against, which are now beginning to manifest. It was not one of the bills that we said we will ensure that these ones do not get passed into law, because that one was more or less part of the economic policy of the government, that this is how they want to go about it. So you let them go. You warn them, you draw their attention, but you let them go. The consequences we shall all feel. This one affects one of our fundamental rights given to us by the Constitution 1992. And we have served notice that if they are included in the bill that comes before the House, we will adopt every legitimate means to ensure that it doesn't become part of the final bill that is passed. In fact, even if they choose to use their numbers, there are still legal means outside Parliament that we can use to get those parts of the bill declared unconstitutional and expunged from the bill if it has become an act of Parliament by that time. So this one, we are serving a different kind of notice because it affects fundamental human rights here in Ghana. And that's therefore how high we are going to take the advocacy.
Let me ask, the minority believes in the court?
The courts are all we have.
The minority believes in the courts?
The courts are all we have. We disagree with some of the pronouncements of the courts, but we have to respect them. And we have to urge on the courts and on the consciences of the justices that the decisions that are being made are decisions that posterity has to live with and posterity has to judge. And those decisions where we feel are not going in the right way, we will avail before the courts the authorities, the evidence, and whatever is required. And like we say in law, pray the court to do justice in those matters. The courts are all we have.
You mentioned something about Gold Board, just for clarification. Is it a statutory corporation now?
It is. It's been moved from a company
with shares
that had been capitalized by the government and owned through the, I think at the time, the finance ministry that owns all of these companies, but with policy direction from the Ministry of Lands, now to a statutory corporation. So their stature is very different. And it rather takes us back from where we were when we were managing state-owned enterprises. Because a lot of those state-owned enterprises were corporations, which were then transformed into companies to improve the levels of financial management and transparency. Now we've gone back.
Wow.
But I'm sure the issues about those will come up as we go along to have an opportunity to interrogate those numbers.
But Honorable, the conversation, we are bringing it to an end, but I want to raise this point. You agree with me that there is the media space is highly polarized, the sense that people are using unprintable words and others. You don't think that maybe when we pick the salient issues that affect the inherent rights, probably that affect our existence, when we put it aside, there are some portions of speeches like hate speech and others, because I remember one time someone forwarded a commentary by one guy, I think on a radio station, that you do galamsey, and that
I sued him.
I sued him. Kojo Oppong Nkrumah.
I sued him. Okay. I sued him. He had to come and settle because that was purely defamatory, of no basis. But in the political space, he thought that he could just slander me or defame me and cause disaffection for me. Now, that is how you deal with falsehoods. There are a lot of civil remedies. But to escalate it to a crime, for example, that we would then now come to a conclusion that because that person said that thing very untrue about me, I was very, very unhappy with it, for which reason I issued a writ against him. He should now be made a criminal, cuffed and put into jail. I would defend him on that no, he has a right even to do that. But when he does that, he will be subjected to civil remedies. But no government, our government didn't do it. No government should say, therefore, that when he says something that is untrue, because I dislike it, he should be jailed. No, that is not something we should countenance. The last remnants of those laws were the criminal and seditious libel. They were cleared from our books. We shouldn't be going back to them. So you may disagree with what somebody says, but you should defend his right to say it. And if he defames you, sue him.
You would agree with me that defamation will take a number of years before you get your resolution in the court?
The position of criminal law is that it is best for 1,000 guilty men to walk free than one innocent person to be incarcerated. The second point I'll make to you is that there are some freedoms that when you take away from the society degenerates.
Okay.
The wheels of justice grind slowly, but they grind.
Well, I am very much aware. My last question for you, that is your chambers, Nkrumah and Associates, are soliciting for Kwame Bafo Abronye. How far with his case?
He's been charged. They've done some disclosures, and we are preparing to appear before her ladyship at the next appointed date. We have our litigation strategy at the back of our pocket, and when we appear before her, we will advance it.
Your Honorable Vincent Kojo Oppong Nkrumah, thank you so much for making time to have this conversation with you. I'm sure that as your private members bill keeps on developing, every stage you would have the time to have some 5-10 minutes conversation.
I'll be happy to carry on.
Sure. Thank you so much.
Thank you so much. All the best. Yeah.